Hi again, this is Amy FitzGerald from the BC Society of Transition Houses. So I'm going to start our family law and frontline work legal toolkit webinar right now. So I'm going to do a presentation for about 40-45 minutes, and then we'll open it up for some questions. In the interim, if folks want to type some questions in the chat box, that's great. I can answer them at the end. And then you can also have them answered at the end when we open it up for discussion and questions. So again, for folks who don't know me, I'm the Director of Training and Programs here at the BC Society of Transition Houses. I was originally hired to work as the legal coordinator here, and I developed the BCSTH Legal Toolkit manual that all the transition houses have and is also available to download off of our website. The legal toolkit is based on collected legal concerns that you provided us as to what were the pressing legal issues that we tried to respond to. It is a living document in the sense that we are revising it, if you have any suggestions as to how we should revise it going forward, please let us know. I'm going to be doing 3 webinars in 2017, one on family law today. March 7th, we're going to be doing one on MCFD, and then on March 28th, we're going to be doing one on Crown Counsel, and we have 2 Crown Counsel from Vancouver who kindly offered to join us for that webinar. There's also going to be some in-person trainings in 2017. I'm going to be doing one in Surrey in March 13th and 14th. And also I'm going to be combining forces with the CWWA folks and doing one in Richmond in May in 2017. So those will be in-person legal toolkit trainings. Today we're going to be recording this session, and we'll be placing this on our YouTube channel. So it'll be available for you to review at a later date. So let's dive into the Family Law Act. So this is who I am again. This is how you reach me. This is my email address and my phone number. And feel free to contact me about anything we discussed today and going forward about any legal issues and also any training or program issues. So with respect to the Family Law Act, we're going to be doing an overview of it today, briefly, and then we're going to be talking a little bit about some recent case law and how that case law can help you in the work that you do every day with moms and kids. So as you well know, the Family Law Act came into effect in March of 2013, and it replaced the former Family Relations Act, which had been on the books since 1970. So it was a pretty significant change in legislation with this new law. And it took a very different tack in terms of family law cases. The complaints with respect to the Family Relations Act was that it was a very litigious act, and that it required a lot of time in court and a lot of money in court. And so what was attempted to do with the Family Law Act was to emphasize out-of-court dispute resolution processes through agreements and through alternative court options such as mediation, arbitration, and parent-child coordination. And so it really shifted, the Family Law Act really shifted the focus away from courts to really the court being the last resort. And it also placed a huge emphasis on the best interest of the child as being a primary decision component when you're deciding issues with respect to parental responsibilities. And it did away with the old terms of custody and access and introduced some new terms about parental responsibilities. And so we'll talk a little bit more about it. But there's some new terminology in the Family Law Act that it's important to understand given the work that you're doing every day with your clients. The other important piece of the Family Law Act that we're going to talk about is it defined family violence, and it's an expanded definition of family violence. And The piece about it is that as part of that definition is that it includes physical abuse, sexual abuse, and attempts to do the same. It also includes psychological or emotional abuse of a family member, and in the case of a child, direct or indirect exposure to family violence. And what you'll see in some of the case law is that in some of the cases have decided that when there's been family violence directed at, let's say, a mom, that has an indirect or direct effect on the child, that they're equating that both behaviors as family violence. So it is an expanded definition, and it runs throughout the new provisions in the Family Law Act. With respect to the parenting provisions that I talked about a few minutes ago, the other part about the law is this change in language. So instead of referring to the old terms of custody and access, the Act refers to guardianship, and parents are assumed to be guardians, and they break up the parents' or the guardian's parental responsibilities. And so it is supposed to allow for a more customized parenting arrangement. And they take a lot of factors into consideration when they're trying to break up that arrangement. But I think for folks who've been doing this work for a long time, we all tend to go back to the language of custody and access. And really today, under the Family Law Act, we're talking about parental responsibilities and whether people have the ability to follow through on those parental responsibilities. And those that criteria may change over time depending upon the nature of the relationship and depending upon the age of the children. So those are sort of just big kinds of shifts in philosophy that the Family Law Act represents. That's just very important for you to know as a practitioner working with children and moms. The other part of the Family Law Act is that they have some compliance provisions in there when people do not comply with court orders and when people use the courts and specifically litigation to abuse the other partner. So there are some compliance sections in there that hopefully will be helpful going forward in terms of controlling some of the malicious behavior that can go on with family court cases. So that's just sort of a brief overview of the Act, and we're going to jump now to talking about the huge emphasis in the Act to refer cases to alternative dispute resolution options. And as I stated earlier, this is really a big shift from the Family Relations Act, where most cases were adjudicated or decided in courts. Here, the purpose is the goal, I should say, was to try and provide cheaper and faster options to resolve family matters. Whether that's playing out in reality, I think it's a work in progress. But that was the goal behind the Family Law Act in terms of emphasizing these out-of-court dispute resolution processes. So the Act itself requires lawyers to explain the different resolution processes to their clients, requires the people involved in a family law dispute to consider these alternative dispute resolutions. And those include mediation, arbitration, parent coordinators. So they're pushing sort of a collaborative settlement process as the first step under the Family Law Act. As part of that, the folks who are engaged in these collaborative or alternative dispute resolution processes are required to screen for family violence. So they're required in every single case, based on their assessment, to make a determination if the case can be dealt in this alternative court process. And it's a fairly controversial area, to be quite honest, because of the fact that there are many in the field who believe that family court matters are not suitable for mediation or collaborative negotiation because of the power dynamics involved, especially when violence against women and children are present. So what they attempted to do to respond to those concerns was to have every single case screened for family violence. And that's where the definition of family violence comes into play again. So this broad definition is a definition that they're supposed to be looking at when they screen for family violence. These folks, the arbitrators, the mediators, the parenting coordinators, they're all required to take at least 14 hours of training on domestic violence or family violence as part of their professional responsibility to do this family screening. And I would say that it's a work in progress as to whether that training is sufficient for the screening that they're doing. Many of these folks are wearing multiple hats. Some mediators are also lawyers, some arbitrators are also lawyers. So it's a combination of professions who are doing this work. But the important thing to know about is that while they provided these out-of-court resolutions, they also mandated this screening process. If the folks that are doing the screening identify that there's no way that they can use alternative out-of-court dispute resolution processes because of the violence that's presented there, then the case would be referred to court to be resolved, for the remedies in court to click in. What we are seeing in the practice is that there are some resources for mediation referral program. So the Family Mediation Pilot Project, which is a project between LSS and Mediate BC, are offering, it's for clients that qualify financially for legal aid but don't have, and it requires a referral, to Mediate BC, and it's for 6 hours of paid family mediation services. Oftentimes these 6 hours may not be sufficient. So if you are referred, let's say, for the 6 hours and your case is not resolved within that time frame, then people are finding themselves in a situation where they then need to pay private pay for mediation, private pay for parent coordination. There are some services provided by the family justice counselors in some communities with some supports there. But one of our concerns with respect to the alternative dispute resolution process is that folks are ending up paying there in a similar way as you would pay if you had the resources to pay for a lawyer. So without sufficient resources, it may undermine the ability to folks to engage in this out-of-court alternative resolution process. The other piece to be aware of is, as I indicated, is the focus of the Family Law Act on the best interest of the child as being the only consideration when making decisions affecting the child. And this is really something that I think as Transition House and CWWA workers, you can use this in your relationship with the courts and with MCFD, because it lays it out very clearly. And so to be in the best interest of the child, the decisions must, to the extent possible, protect the child's physical, psychological, and emotional safety, security, and well-being. And they list the factors of what needs to be considered. So it's basically all of the child's needs and circumstances. And this is also a shift from the Family Relations Act, where the best interest of the child was considered important and paramount, but it was not considered the only consideration. So the Family Law Act, under the parenting provisions, it lists, again, the child's emotional health and well-being. It also is, under those factors under the Family Law Act, the court is required to listen to the child's views unless it would be inappropriate to consider them. And they would take into consideration the age of the child, the emotional development or vulnerabilities of the child in making that determination. But that's also a shift from the Family Relations Act. Under the old Family Relations Act, the child's views would be allowed if appropriate, but here there's really a focus on listening to the child's voice. And you'll see that in some of the cases that we're going to review today. 11-year-old children testifying on behalf of their needs, for instance. The other criteria that the court's going to look at under the best interest of a child is the child's relationship with parents and guardians and other important people in their lives, the history of care, who's been providing the care, the need for stability given the child's age and development, the parent's ability to meet their parental responsibilities, and whether the parents have any impairment in terms of meeting those parental responsibilities. And you'll see that some of the case law we're going to talk about later it has concluded that parents who engage in coercive control behavior, that impairs their ability to meet their parental responsibilities. So there's some good case law and some good language in here in terms of supporting the work that you're doing on a daily basis in terms of advocating for the women and kids that you work with. The other things that they're going to be considering about is whether it's appropriate to have any arrangements that require parents to cooperate, any civil or criminal proceedings that relate to the child's safety and well-being. So they're attempting to capture some of the information sharing that's very important and has been sort of missing, I would say, in some of these court processes. Certainly we have a long way to go on that, but there's language in there to open those doors. And then one of the most important criteria that has to be considered under the best interest of the child is the impact of any family violence. So if there's any allegations of family violence in the case, then it triggers the next section in the Family Law Act, which is Section 38, which provides specific guidance to the courts to consider when they're looking at the best interests of the child, when they're assessing for family violence. And this assessment is mandatory if there's an allegation of family violence. And so the criteria that they have to consider there are the nature and the seriousness of the family violence, how recently the family violence occurred, the frequency of the family violence, whether there's psychological or emotional abuse, a pattern of coercive and controlling behavior directed at family members. So there's language in there, in the statute itself, that talks about coercive and controlling behavior directed at a family member. Whether the violence was directed towards the child, whether the child was exposed to family violence that was not directed towards them, the harm to their physical, psychological, and emotional safety, as well as to their security and well-being as a result of the indirect or direct family violence. Any steps the person responsible for the family violence has taken to prevent further violence from occurring. And then any other relevant matter. So there's sort of a catch-all at the end to capture any and all family violence matters. The idea behind this is to try and have a really detailed, nuanced assessment when considering what's in the child's best interest and what kind of parental responsibility arrangements are in the child's best interest. So there's good language in here in terms of listing criteria, and the way the courts have decided the best interest section in the Family Law Act is also helpful. And I want to apologize that I didn't get those case sites. I've just got a question from Donalda saying that you can't hear me. I'm going to unmute folks and let me know, can you hear me?
The conference has been unmuted.
Can folks hear me?
Yep, I can hear you.
Okay. Donalda has indicated that she can't hear me. So, but you guys can hear me. Okay. I will try to help Donalda. Okay, so I'm going to, is it making sense? That's my next question to you. What I'm saying to you guys that can hear me?
Yes.
Okay, great. All right. I'm going to go back to muting, and then I'm going to type to Donalda and give her some help to try and get in.
The conference has been muted.
All right. So the cases that I'm going to add them to this PowerPoint before we post it on YouTube, so you'll actually have the sites to the cases with respect to the best interest of a child. So what they are basically stating in these cases is, and I won't give you the titles of the cases because I'm going to be posting them, but they go through this factor by factor analysis of all the things that we just talked about. The issues as to the family violence, the issues as to the criteria as to the history of care, the impact of family violence, the nature and seriousness of family violence. They go through them one by one to consider separately, and then they also have to consider them as a whole. So they take sort of the assessment of the impact of family violence as a mandatory criteria, and then they go through all the factors, and then they take it sort of as a comprehensive analysis of it. And they also indicate that expert evidence may assist the court's analysis for that. So that's another piece that's important to know, is that there are they do open up the door to have psychologists and psychiatrists and even parent coordinators to help with respect to determining what's in the best interest of the child, and the courts are open to that, and they encourage that. And I will add those to our slides when we do post them. So I'm going to move on now to, this is some family law resources for you. So this is a link to the actual Family Law Act itself if you want to take a look at the criteria that I'm referring to now. And this is also a link to a good resource to have. So this is Ministry of Justice Information Bulletin that they put out in August of 2015 at our request, specifically because of concerns with respect to the implementation of the Family Law Act, and also with respect to issues related to CWWA and some of the issues with one parent objecting to CWWA seeing children. So this is a good resource for you guys to have going forward. It's a very useful information sheet to have. And now we're going to move on to some actual cases that I promised that we would talk about that really illustrate some of the points that I've been making in terms of how the Family Law Act is rolling out in real time. And hopefully some of these decisions will help you in terms of when you're working with folks in terms of identifying what criteria is important for them when they go to court to address some of these issues. So bottom line is the family violence definition that we talked about in the Family Law Act has been defined by the courts in a very broad way. And so, which is good for us in terms of that there's a lot of information that can be used then to support women and children going forward. So this case, this first case that I put up here on the slide, it's an interesting case. It's from 2013, and then we're actually going to follow it with a case in 2014. It's the same case, but it's a year later, and you'll see how things have deteriorated in that time frame. But this case, the DNL versus CNS case, is a case where demeaning, derogatory outbursts and remarks that were blaming the parent directed to the child were found to be emotional harm and were deemed to be family violence under the Family Law Act, and allowed the judge to take into consideration that family violence when they were drawing up parental responsibilities to it. So the quote here talks about, and the judge in this case actually really took all those factors that we just talked about into heart and listed them all one by one by one, and felt and made a very, very detailed decision about this family. So this just gives you a sense of where the courts are going. So specifically, talking about the mother in comments to the child that her mother's in therapy, that the child is being manipulated by the mom, that the child is responsible for the failure of the parent to communicate with each other. All of this sort of psychological abuse, and you probably are familiar with, but again, it now is equated by itself to be emotional harm and family violence. The interesting thing about this decision also is that the judge talked about the sort of the inclination in family court cases to provide maximum contact between child and parent. And the judge indicated that you had to balance that sort of long-standing assumption with what's in the child's best interest. And the child's best interest is most important, and that means the child's emotional safety, security, and well-being. The child in this case was an 11-year-old child, and the court took testimony from this 11-year-old child that she found was very compelling and was very helpful in terms of making her determination. So that's, like I stated before, it's interesting to see that rolling out under the Family Law Act, and there definitely is an encouragement to have children testify. The other, the nature of some of these derogatory comments related to child support, reducing child support, derogatory comments about religious practices, and also the father in this case kept a court file that he let the child know about, where he was basically keeping notes about the court file, and then he was sort of using that in the communications with the child, which upset the child because the child felt like she was causing all this court work and all this litigation to be going on. It's interesting in that the negative comments also with respect to the child, they put actual quotes when the court took the testimony from the child. They actually answered put actual quotes of what the child said in the case. There's a question here from one of you guys, and I'm just going to, looks like Donalda switched to the phone, so hopefully that'll help. Sorry, Donalda, for the audio issues. So Tina's wondering, how did the 11-year-old provide testimony to the court? So in this case, I believe it was directly to the judge, and I've got the case in front of me. And I read it, to be honest, a while ago, but let me double check to see if I can answer that question right now. So it looks as if it was done in the context of a deposition, Tina. And I can get more information about that, and I can post it to find out exactly how that was handled, if that's okay for you. So I'll keep your question as a placeholder and follow up with that, because that's a good question to ask about how this works in real time, right? Not just on paper in court cases, like the ones I'm looking at. So this gives you a little bit of a snapshot about how the best interest of a child is being decided by a judge. And then we're going to skip ahead to some additional cases. And I think I'm going to do right now is I'm going to skip to the second one on this slide, which is the same case, but in 2014. So, and then we'll go back to the MWB case, which talks about the broad view of what constitutes family violence. So this is the same case a year later, and things have deteriorated significantly in that time frame. And the end result of this case is actually that the judge stops the father from having contact or parenting time with his 12-year-old daughter, and basically decides that it's in the child's best interest to do so, and also it is up to the child to decide when she wants to re-engage with the parent for parenting time. So it's kind of an interesting case to watch in terms of what happened and what transpired within that year. And again, child's 12 years old. The judge again comments about how the child is very clear, and she gave significant weight to the child's testimony in terms of what she wanted. She categorized her as an intelligent, mature child, capable of providing clear reasons for her preferences. Her views, although not determinative, deserved significant weight, and she specifically stated that she did not want contact with her father. So, and again, I'll figure out the nuts and bolts of how she got that testimony for you again and relay that information. So what happened with this case in the year in terms of was sort of all the bad behavior we saw in the 2013 case just continued. But in the interim too, they had engaged in parent coordination process. So they had an experienced family law mediator, an arbitrator. They had the assistance of a child psychologist. They had a parenting coordinator who had issued numerous decisions adjusting, suspending, and reinstating the access to the child between the father, and it just deteriorated. So a lot of effort went into trying to create a successful sort of parental responsibility engagement, and it just became a significant source of conflict over that 1 year period of time. And the interesting thing also about this decision was that the judge stated that and I want to get the quote because it's particularly interesting, I think, given the nature of the work that we do. It said that the father's behavior has deteriorated to the point where the child refuses to spend any parenting time with him. The outbursts of anger have escalated. His accusations of the claimant has turned the child against him, and his demeaning comments, not only about the mother, but also about the maternal grandparents and other family members. So again, that's looking at one of those factors about the child's relationship with other family members as well as part of that best interest criteria. His threats to use force to compel the child to accompany him and have all caused emotional distress and further undermined his fragile relationship with his child. And the judge says the respondent's failure to refrain from this behavior. So she's placing all the emphasis on his behavior, and his failure to stop it and not engage in it is destructive to his relationship with his daughter and has resulted in the current circumstances and the family violence and emotional harm. So it's an interesting decision because it's clearly placing the burden on the father, on his behavior, in black and white. So that's, I think, an important, thing to think about, and to think that the Family Law Act actually can allow for that controlling, coercive behavior to be identified, and to be identified as emotional abuse and emotional harm, and that the court would take an action that takes into account the best interests of the child and listens also to the voice of the child in terms of identifying that they didn't want to have contact with the dad. Then I'm going to skip back to the MWB case that I skipped over because this is also this case also gets cited a lot, the MWB versus ARB case, because of the fact that it provides some good language in there about that the court needs to take into account sort of a broad definition of family violence when determining these cases. So specifically in this case, the court identified litigation conduct that was excessive as being emotional abuse and harassment that constituted family violence. Needless litigation damaging the other partner's financial well-being and health, litigation causing using up emotional and financial resources. And so you've got this very contested litigation going on in the MWB case, and then the court determined that the best interests of the child suffer because of this oppositional behavior and litigation going on that is being caused by one parent. So that's harming the health and the financial well-being of the parent, which then in turn harms the child's economic safety and security. And it goes through all those factors that we just talked about being oppositional and reckless and using coercive and control. And in this case, the abusive conduct actually was noted. It caused the other partner to have to take a stress leave, and that stress leave, instead of being seen as sort of a vulnerability of the other parent, that stress leave was seen as something that was negatively impacting the child's security and emotional health, but the blame was placed on the person who was causing the stress. So it had indirectly harmed the child's psychological and emotional well-being, but the blame was being placed on the person who was engaged in the conduct that was creating that. And again, this case also goes through all those factors that we just talked about, sort of a step-by-step analysis of all the child's needs and circumstances in terms of determining how to identify the family violence, and then to determine what's in the best interest of the child when you're coming up with the parental responsibilities for the children. The next case is the KLL versus DJ. I'm skipping over the DNL case because that's just a cite to the case that's on the slide before that we just talked about, but that's the cite right there if you want to look at the 2013 and 2014 cases together. They're both there. The KLL case is an interesting case to look at because it has, as they characterize, de minimis or minimal physical contact was alleged in terms of a family violence case. And so this is a case where it was characterized that one party put there, and this is a quote, he put her hands on her once. And the court characterized it as a minor end of the scale in terms of physical violence, but the court also noted that there was evidence of psychological or emotional abuse, including intimidation, harassment, coercion, and threats. So even though that the physical abuse was minimal, that the additional intimidation, harassment, coercion, and threats, and derogatory comments also were noted in this case, were enough to identify that this was indeed family violence and that protection, in this case it was a protection order case, and that a protection order was granted. This case also cites the MWB case, which we just talked about, which talks about having the broad view of what constitutes family violence, and it also cited the DNL case that we just talked about. So it sort of gives you a sense of how these cases are kind of nesting with each other in a good way in terms of supporting each other. The other thing to be aware of, and I will add these case sites because they're not in our slideshow today, is that there's some other protection order cases that have decided given the family violence definition, an expansive definition. So it specifically would allow for sort of hopefully a more protective and increase in protection orders being issued by the court. So there's a case called Morgadinho versus Morgadinho from 2014. The BC Supreme Court says that protection orders can be made even without physical violence. The courts have recognized that threats and words and emotional abuse constituted violence. And then the other case is Dawson versus Dawson, also from 2014. And the court there found that even a single act may suggest that violence is likely to occur in the future and can be interpreted as being a basis for family violence that would occur in the future, and there's a need for a protection order to protect from the potential gravity of the violence. So those are two good cases in terms of protection order, again, demonstrating sort of the broad definition of the family violence statute. And like I said, I'll add those to the PowerPoint. So we're just going to talk about a few more cases, and then we'll open it up for discussion and questions. So this case is, I'm circling back to the MWB case that we talked about a few minutes ago, and the reason I'm circling back to that one is because, and I mentioned this at the beginning of our discussion, but the Family Law Act also added provisions in there in the law to address I apologize to folks, there's a fire alarm going right now. I'm going to pick up my hands-free to see if this is better. All right, I apologize for the fire alarm in the background. I'm going to talk louder. So in the Family Law Act, it allows for provisions in there to address when you have litigation abuse. And specifically, the provisions that allow for it are, it allows the court to set aside decisions. It allows for the court to delay proceedings if they feel that there's litigation abuse going on. And it's mentioned in that decision, the MWB decision. So it's just important to know that the Family Law Act, and so it is a more fulsome way for the court to be able to respond to litigation abuse. That they can dismiss or strike out any or all parts of the claim. They can adjourn the proceeding. They can require all matters to be heard by the same judge if they feel like people are judge shopping. And so they have methods to prevent the misuse of the court process. That's part of the Family Law Act at sections 222 and 223. So again, remedies to think about going forward if you end up with a client in that situation. And those are discussed more specifically in the MWB decision. So with respect to the next case, this is a case where it's focused on financial hardship and stress related to financial hardship and threats to cause financial hardship. And the court there determined that that kind of behavior equates with emotional harm, emotional abuse, and is family violence. So this is a case where a very well-heeled person failed to pay child support. And there was significant court action with respect to that. He was threatened with contempt. He was a dentist. He was very financially able. There was real financial inequality in this relationship, and he knew that, and he used that to sort of make comments about he was going to sort of ruin their lives by closing his dental practice and threatening to destroy them with respect to his ability to not provide for them financially. So his failure to pay the child and spousal support, he also was very, very litigious. He used emails excessively, and so the court found that all of this behavior was deemed abusive, and to the point where it was identified that the mom developed such stress and such emotional harm that she had symptoms of PTSD. And that was identified actually in the court decision. And so, again, something to think about in terms of going forward with these cases, that actual, sort of threats with respect to financial hardship can be deemed family violence and can be actionable in these cases. The next case is again sort of provides more emphasis on the failure to pay child support, which is intended to inflict emotional harm and control, is again identified as controlling and coercive behavior, is equated with family violence. The other thing I just wanted to double back for a second to the Hochhold case. The other thing that was interesting in this case was when the spouse was very litigious. He would also use, he would videotape portions of his parenting time with the children, and he would videotape exchanges of the kids back and forth, and then he would edit the videotapes to make himself look more suitable as a parent. So there was a lot of technology in this case in terms of use of the excessive emails and also the use of sort of videotaping on phones that the court basically said was all part of his sort of coercive and control behavior and equated with emotional abuse and family violence. With respect to the JCP versus JB case, this case was a little bit simpler in terms of the facts, but the court interestingly concluded that a failure to pay the child support was a calculated and deliberate act designed to inflict psychological and emotional harm to both the mom and to the child, and to destabilize the mom's ability to parent the children. So that was sort of an additional interesting twist to the characterization of the coercive and controlling behavior. And then the final thing was that it also demonstrated to the court the father's inability to care for the child. So again, we talked about one of those factors was their ability to engage with their parental responsibilities and do what's right, but also whether they were in any way impaired to do that. And in this case, they felt that the court concluded that the coercive and controlling behavior by the father demonstrated an inability for him to care for the child, and that his his parental responsibility abilities were impaired, and he had poor decision making, in terms of relationships with his children because of the coercive and controlling behavior. So interesting language again. It's all this behavior is very familiar to you in terms of the work that you do on a daily basis, but also good to know that the courts, at least in some of these cases, are identifying that this is a reality and that it has harm to both the mom, it has harm to the children, and that the courts are trying to at least name it and address it in terms of the orders that they're making with respect to the children and parental responsibility and what's truly in the best interest of the children. So we'll move on to my last slide, which is questions and discussion. So I'm going to unmute at this point, and I'm going to turn off the recording button. So and then we'll take questions by folks who are on the phone, and then we'll also, folks can also use the chat function. So it is 12:53, stopping the recording and unmuting.